everybody right now is saying that there was a Trump victory in terms of the Supreme Court decision, which upheld his travel restriction. It wasn't a Muslim ban. That's what the ACLU was saying. It's not a Muslim ban. The countries that he actually had listed represent about 8% of the entire Muslim population of the world. He would have gone after Indonesia. Everybody knows that this is a no-brainer of no-brainers. And what this is an example of how to do exactly what the Supreme Court is supposed to do. Read a statute. See if there's anything about it that was unconstitutional, an improper delegation of authority, etc., etc., etc. Look at the particular language of the president's order. See if it complies, see if it comports, see if it in any way violates any particular precept, provision, I should say, of the Constitution, Bill of Rights, whatever it is, statute, treaty, anything. And if all of that checks out, you may not like it, you may not care for it, but there's nothing unconstitutional about it. So the Supreme Court upheld the travel ban, which seemed to, some would say, mostly target Muslim majority countries. That's the way it was phrased. But that does not mean that that was the sole basis of the targeting. And I would even submit that had it been, it would have also been legal. Now, the ban, however, I'm looking at the particular case right there. The ban was challenged apparently as an improper use of the president's authority to suspend and to interrupt and to affect trade, I should say entry of foreign nationals into the U.S. And they're suggesting that Trump, in his particular doctrine, gave instances of a personal bias against Muslims. And what it did was it affected, it contaminated, it rendered contaminated, I guess, the president's executive order. And he also used extrajudicial comments and from other people to show, to kind of bootstrap that the real basis, the genesis, the gravamen of his particular problem was on some kind of anti-Muslim bias. And that it violated the First Amendment's Establishment Clause. It was just, they threw everything at him. And the Supreme Court, in a 5-4 decision, said, no. A 92-page ruling, Justice John Roberts gave the majority opinion. And he said, first of all, this is important. It's very, very clinical, very, very clinical. The court first ruled that the executive order was a valid exercise of the presidential authority that was given him under 8 U.S.C. 1182F. This is the inadmissible aliens statute, which was codified into federal law. This was the law. Now, you may not like that. You can strike down that law. They didn't. That's the law. Now, if the law is not a problem, or if you can't strike the law down, and if the president utilizes the law, well, you're, as we say in the legal biz, SOL. And the court ruled that Section 1182F exudes deference to the president in every clause. It entrusted the president the decisions whether and when to suspend entry, whose entry to suspend, for how long, and on what conditions. It thus vests the power in the president with ample power, quote unquote, to impose entry restrictions in addition to those elsewhere enumerated in the Immigration and Nationality Act. Translation, the president's got a lot of authority and he utilized it, and that's the way that goes. So in ruling against remember this was the state of Hawaii, this was their claim that Trump had, he had issued this executive order based upon some anti-Muslim hatred, animus, disposition, predisposition, proclivity, whatever. SCOTUS made it very apparent that he and many of his advisors and that sort of thing had indeed expressed his sentiments, both during the election period on television and elsewhere, and during his time in office, but ruled that those statements, those extrajudicial statements, those not ex officio, but those extraneous statements were not significant when trying to assess a matter, quote, a matter within the core of executive responsibility. So what they said was, yeah, that's nice, But that in no way is going to invalidate the particular ability of him to exercise something. You could say, and politically may be disadvantageous, but you could say a lot of things. So long as when you apply the statute and you use it for the statute was intended to provide, as long as you follow the law, doesn't matter really what you say, nor should it. Now, according to the Supreme Court, the anti-Muslim bias that was alleged, these statements, these feelings, this animus, if you will, simply, the court said, were not enough to overcome the travel bans, and this is a critical word, facially neutral legal posture. Remember, the president is basically utilizing a statute. You know, and if I mean, this is a terrible example, but if I'm a police officer and I hate Alsatians, but there's an Alsatian who happens to be speeding, literally speeding, he's speeding. And it may just happen to be that I pulled over somebody who's breaking the law, whom I hate. And again, it's a bad example, but maybe it's not a bad example. To me, it's a good example. It doesn't invalidate the speeding ticket just because my particular animus, if there is such a thing. So, in other words, the court said, because the ban itself does not contain any Muslim bias, any explicit anti-Muslim sentiment and the like, the court decided to basically to trust and give weight to the word of the administration's attorneys that the ban that was entered was not simply some kind of a pretextual, pretense, some hidden, cryptic way to actually go after people that he hated. But the court just said, we're just going to take the lawyer's word on it, especially when you're basically following the letter of a law, which the court rules was legal. Listen to this final language. The ban is expressly premised on legitimate purposes and says nothing about religion. The entry restrictions on Muslim majority nations are limited to countries that were previously designated by Congress or prior administrations. Emphasis on that. As posing national security risks. Moreover, the proclamation reflects the result of a worldwide review process undertaken by multiple cabinet officials and their agencies. Plaintiffs, state of Hawaii, challenged the entry suspension based on their perception of its effectiveness or wisdom. But the court cannot substitute, and you read this all the time, its own assessment for the executive's predictive judgment on such matters. And there you have it. Very simple, very basic. I know this is going to upset the Maxine Waterses of the world. I know this is going to be reviewed by the God knows what, this rancid, exceedingly violent, physically and verbally left and anti-Trump group. But it is simply a fact that the court exercised its ability to do its job under the Constitution. And if you don't like it, you should go back and repeal that statute, put in new language that, give it a shot, that specifically eliminates the president's ability, and this may be problematic, but if you don't like the statute, put in something that prevents any limitations of entry to be applied to Muslim countries and the like. I mean, good luck with that one. That may be a bit of a problem, but this is just one particular review, one particular aspect of trying to advance a particular cause. And based upon the allegations made by the state of Hawaii, fine, how are you? The court ruled, I believe, and I submit correctly, that there was nothing unconstitutional or impermissible on the part of the administration. That's it. It's a no-brainer. That is it. Please like the video. Please put your thoughts, comments, observations, witticisms in the like below. Please subscribe to the channel. Please hit that little bell so you'll be notified of live streams and new videos. And whatever I do, or you do, I beg, beseech, implore, and importune you to always comment as you see fit.